Court's in session, phones on silent, brains on. Today's defendant is a national outlet that ran a 5-alarm headline. One judge tells ICE to stop. The Supreme Court already said no. It says the court already banned what this judge did. There is just one problem, jury. Read the article printed under that headline, and the same reporter admits the judge did nothing the Supreme Court forbade. When a headline and its own body text disagree, one of them is evidence. Let's read the file. Here is the charge, word for word, so nobody says I twisted it. On June 30th, the Daily Signal published a headline that reads, "One judge tells ICE to stop. The Supreme Court already said no." The whole thing rests on that phrase, already said no. That is the accusation. A rogue judge defied the highest court in the land. Hold on to that claim, jury, because we are going to hold it up against the outlet's own reporting and against what the Supreme Court actually wrote. So let's establish what actually happened and mark it as Exhibit A. On June 23rd, a federal judge in California, P. Casey Pitts, struck down 2 Trump administration policies. One let ICE arrest immigrants at courthouses. The other let the government hold them for up to 72 hours instead of the long-standing 12. He did it through vacatur under the Administrative Procedure Act, the law that lets a court throw out an agency rule it finds arbitrary and capricious, not a nationwide injunction, vacatur. That distinction, jury, is the entire case. Now, let me show you what the Supreme Court actually said, and mark it as Exhibit B. The headline leans on Trump v. CASA, the 2025 decision that curbed nationwide injunctions. Here is the part the headline skips. The CASA majority went out of its way to say it was not deciding whether the APA lets a court vacate an agency rule. In the court's own words, nothing in the decision resolves the distinct question whether the APA authorizes courts to vacate federal agency action. The court limited one tool and expressly left the other untouched. So line up the 2 exhibits and let them convict each other. The Supreme Court limited the injunction and left APA vacatur open. Judge Pitts used APA vacatur. He reached for the exact tool the court left on the table. So the accusation that he defied the Supreme Court is not a stretch of the facts, jury. It is the opposite of the facts. And the best witness against that headline is about to be the outlet's own reporter. This is not my reading. It is theirs. Read the Daily Signal's own body text, 4 paragraphs under that headline, and here is what the reporter wrote. The judge, quote, "isn't operating in defiance of CASA. He's operating in the gap the court left open." And, quote, "the CASA majority explicitly left APA remedies intact." That is the outlet's own reporter. He wrote the refutation of his own headline and ran both on the very same page. So who benefits from running the false headline over the true reporting? Not the reader, who leaves believing a judge went rogue. The beneficiary is the frame. Rogue judge defies the Supreme Court gets clipped and raises the temperature. The judge operated in a gap the court left open is accurate, and accurate does not go viral. They kept the true version in the body, where fewer eyes land, and put the sellable version on top, where everyone does. And here is the reveal, jury, the part they framed out entirely. Strip away the headline and there are real people in this. For years, ICE could hold someone in a short-term room for up to 12 hours. In 2025, the administration waived that cap and pushed it to 72. That is 3 days in a room built for a few hours. Judge Pitts vacated that waiver and put the 12-hour limit back. That is a judge restoring a rule using a tool the court preserved. Let me say the quiet part plainly. Already said no is doing all the work in that headline, and it is false. The court did not say no to vacatur. It said, in writing, that it was not deciding that question at all. A headline that puts words in the Supreme Court's mouth is not reporting, jury. It is ventriloquism. And the dummy, this time, contradicted the ventriloquist 4 paragraphs down. So here is the verdict. A judge used a remedy the Supreme Court specifically preserved, and a national outlet told its readers the Supreme Court had banned it. Then, further down the same page, it admitted that it had not. That is not a rogue judge defying the court. That is a headline that lost an argument with its own article. When the top of the page and the middle of the page disagree, read the middle. Defense rests. You don't have to. I'm Madeline, and this is Pixel Politics.